Hello guys, this is Billcotey from Billcotey Properties. Today we are at Oyarifa Cottage. We are about to shoot the second episode of Legal Matters with Billcotey. I have your finest also here still. Our legal team is the head, Mr. Doe. We have him here to cover some short topics that we have here. The very first one that we have to talk about is registration of land. How can we register our land? In case you buy a property, you buy a landed property, and you want to register it. How can you register it? How can you do that? Okay. It took us through splitting a property when you guys are divorced and all that, how you are going to go about it in our first episode. Is here again to take us through how to register your land. Okay. Land. So, Mr. Ado, welcome.
Thank you very
Once
much.
again.
Yes.
Okay. So the very first question is,
Mhm.
can you walk us through the process of registering a land when you buy a property, when you buy a landed property here in Ghana? How can you register the land? What is the process?
Right. So, thankfully, the process
Yeah.
of registering land has been codified in a particular law.
Right.
That is the Lands Act of Ghana 2020, Act 1036. So this particular law contains full details of the registration process. First of all, there are various types of interest you can have in land that can be registered. So someone can come and register what is known as the allodial title, the usufruct, a lease
Right.
can be registered, even a mortgage can be registered. So all these are registrable instruments or interest in land. So now the first thing you have to do is that remember land is more or less like a portion of the earth.
Right.
Under the Lands Act, land is the surface soil and anything that is attached on the surface soil. So to register the land, obviously we must be able to identify which portion of the land we are registering.
You are registering.
So the most important aspect of land title registration or registration of an interest in land is to first of all have the site plan, have
Right.
the location of the land, the extent of the boundary, or even the size of the land. That is one of the most important aspects. So more or less, there will be a surveyor who will come in to survey and map out the particular boundaries of the land. So that when you have this, yes, the perimeter, the territory of the land. Everywhere on this particular earth has a territory. They've been demarcated into territories.
Right.
And even Ghana alone has its own recognized boundaries and territories.
Right.
So if you want an interest in land, you are able to identify where that particular land is located and then the exact or the extent of the boundaries to the land. So you submit the site plan together with your registrable interest. It can be documented. So,
But how would they get the site plan? Who does
so
it?
so more or less you have to get a surveyor,
okay.
right, to you employ him or get contracted services,
Right.
and then he'll prepare the site plan for you.
Right.
And then the land title registry, they'll stamp the site plan as authentic. They'll just put their stamp on it, and then it's more or less one of the documents that you can use. Another thing that is important is that you have to know the type of interest you are registering. So I think there'll be another question pertaining to the type of interest we have in land. But then if you get more or less like a lease, you can submit the lease to the land title registry. When you submit the lease is documented on paper. It is in writing with the names of the party. So the lessor and the lessee. So the lessor is the one who is granting you the lease for a number of years, and you are the lessee. So in that case, the entire lease is documented. So even the Lands Act has provided a structure for how to document the particular transaction related to the land or the ownership or the interest. So when it is documented in a lease, for example, then you submit that particular document known as the lease, or probably if it's a transferable instrument, that is the deed of transfer or the deed of conveyance
or the indenture.
The indenture, right? There are so many, there are different terms that you can refer to them. It depending on more or less what is the document evidencing the transfer or the conveyance. So when you get that particular instrument, usually under land law, they refer to it as an instrument. It's more or less like a document, a legal document. You submit that instrument to the Lands Commission and to the Land Title Registry. Then the registrar will do the necessary checks and they'll go through the necessary process. They'll stamp it, you pay the fees to take a number of weeks, months, and then they'll register the particular interest for you. Usually, they will determine whether or not there is a prior existing interest, which is in conflict with yours.
Right.
If there isn't any prior existing interest,
Right.
then we would come to the conclusion that the person who registered this interest has a legal title to that particular interest. So I think there'll be more questions that will lead us to further
Absolutely.
breakdown, but this is just a simple process.
Right.
So you need to identify the land.
The land.
So to identify the land, there's something that's commonly referred to as the site plan. Then you identify the land with the site plan.
Right.
After
With the help of a surveyor, right?
Yes, so an expert
Okay.
who will come and demarcate and you know the exact location of the land.
Right.
Because you should be able to identify the portion of the soil that you are laying claim to.
Right.
So when you identify the land on the site plan, then with that particular thing attached, even that alone, someone who has no documentation, if that person is the original owner, he can carry the site plan alone and say, I'm the original owner, so I'll statutorily declare that this is my land. You can trace my history or my attachment to the land and register my interest.
Okay.
But if you are buying the land from someone, then obviously there'll be a grantor and a grantee, or a lessor and a lessee.
Right.
You get it?
Right.
So in that sense, there must be a document that will show the names of the parties, the date of the transaction or transfer,
Right.
as well as the land, the description of the land, and even the signature of the parties and their witnesses.
Right.
So they are
in the indenture.
yes, in the indenture, right? The document that the document that evidences the transfer or the interest in the land that is being transferred or conveyed. So these are just the basic connections that deal with the registration of land.
Right. And I mean, topping it up, you should be also be able to get the sale and purchasing agreement
Yes.
also
Yes.
in there before you would even get to the indenture part.
So
right?
As I said, there are different interests.
Right.
So if someone bought the
it.
interest in full,
Right.
that means that the person has bought maybe a freehold
Right.
in the particular property.
Right.
Then there will also be a sale and purchasing agreement. I hope you got me.
Right.
But then there are other types of agreements. There's even a usufruct. There is an allodial title. There is a usufruct. There is also.
I mean, that's the types of.
Those are the types of interest. So the sale and purchase, more or less, depending on the type of transaction, the person is buying a common law freehold.
Right.
Right. And then there's also customary law freehold, a tenancy, a mortgage. There are various interests that you can have in the land.
Right.
I hope you got it. Yes. So the document must portray the type of interest that the person has in the land. That is how we go about it.
Okay.
Walking away, your words are lost on me.
Yes. But I want to also touch on this.
Mhm.
I want to know whether if I learned the leasehold and the freehold, the freehold has been scratched off now. It's just left with the leasehold, and it'll be handed over 99 years when you buy a land.
Yes. So when the
that's the maximum years that you can.
Well, you see, a freehold interest is more or less a perpetual interest.
Right.
So now, because in Ghana, there are, I think, 4 main types of land interest. We have the state. The state owns land.
Yes.
So that is the state owned land.
We'll come to that.
But you see, with the leasehold, they give you the land for a particular duration. That means that the original owners still have their rights to the land. But for the freehold, they are extinguishing their full right to the land, and now that is no longer permitted for stool lands and for family lands and clan lands. But if it's your private land as a private individual, you can still give a freehold of the private land. I hope you got it.
Okay, I get it. So let me. So what are the types of land ownership? That's what I was coming to.
That's a very good question.
What are some of
the types? With respect to the Lands Act, right, and under Section 1, there are about 6 types of land interests that we can have in land. There is the allodial title, there is the usufruct, there is the customary law freehold, the common law freehold, the leasehold, and also customary tenancy. So 6 different interests a person can have in land. And those interests are really, really interesting, if I may say so, because the allodial title is the true ownership.
Okay.
Right. So the one who holds the allodial title is the one who has the highest or the ultimate interest in the land.
Right.
So most people operating in Ghana do not actually hold the allodial title. There are only small groups of people that can hold the allodial title. These are the land owning stools. Yes. And then we have land owning families and clans.
Yeah.
Those people are those who can hold the allodial title. And then we also have the state.
The state.
If it's public land, right,
Right.
that the state compulsorily acquires, then it means that the state holds the allodial title.
Right.
So usually, the allodial title refers to those who were of the ancient days who, discovered the land and settled on the land, or they conquered, they fought the wars and they settled on the land. So as far back as the Asante Kingdom,
Right.
all the lands in the Ashanti region thereabout belongs to the Asantes too. All the lands in the Volta region is broken down into various families or various stools. I hope you got it.
Right.
So the allodial title is the original owner of the land. It can also be vested in a private person. So a private person too can be the original owner. That means that there is no other owner of the land. They are the original owners. Then we have the usifact. So the usifact is a member of the family,
Right.
or a subject of the stool. So if the stool has the allodial title, the usifact is a member of the stool. So if all these lands, let's say Oyarifa lands, belong to a particular family, the usifact is a member of the family who can take a portion of the land. He settles on the land, he farms on it, and he has the usifact.
Right.
That is the portion of the land.
Right.
Then we also have the leasehold. So for example, this usifact, who has a portion of the land because he's a family member, he can give a lease. And that lease is where we are coming to, that a lease cannot exceed maybe 300 years. It cannot be that long because it's not perpetual.
Right.
The family must still enjoy the land, right? So usually a lease to an indigene, a Ghanaian person, right? I mean, a non-indigene who is Ghanaian, a lease to that particular person can be for maybe 99 years. Up to, it can be usually 50 years, 60, 70, 80, maybe up to 99 years.
Mostly it's 50 years for non-Ghanaians.
Yes, but for non-Ghanaians, it is this one capped at 50 years,
right,
under the Constitution, under the Lands Act, probably Section 10 of the Lands Act. So you realize that the leasehold is because you are not a member of that particular family, or you are not a subject of that particular stool. So you cannot hold the land forever. So you get a lease. So most of us operate on leases. For if you are a Ghanaian, you can have maybe up to 99 years. If you are non-Ghanaian, then your lease is maximum of 50 years, but it's renewable. You can go and renew the particular lease. Then we also have customary tenancy. These are farmlands. Usually people enter into a busa and a bunu. You farm for the chief, and then you give him a portion of the produce. So that one is not really common. It's in the, let me say, the villages and those places, right? The farmlands. And then we have the common law freehold. So the freehold gives the person full, almost perpetual rights in the land. So that's what you are talking about. That if you are a member of the family or you are a subject, you can get a freehold. I hope you are getting me. Because you have what? Perpetual interest. You are a member of that family or a member of that clan. But if you are no longer a member of the family or a member of the clan, usually you cannot get that customary freehold. The common law freehold is basically a transfer of perpetual interest. That is the sale of the land. So when you sell your land and all your interest in the land to someone, because the land is privately yours, you sell it to another person, it's a common law freehold. It is usually documented in writing with all the particular dealings relation to contracts. It's a sale and purchase agreement. So it's a contract. So the person has sold his entire right in the land to you. So that is the common law freehold. But usually if it is stool land or family land or clan land, you cannot sell the whole land to the person, or the whole interest in the land to the person. It can only be a portion or a duration of the particular interest to the person, like a lease. I hope you got it.
Can you state some of the ownership? Can you state it and say, look, this one you can sell it, your right to it. This one you can't sell the entire right.
Yes, I can do that. So allodial title is the complete ownership of the land. So if someone has allodial title, it means that perpetually he and his family and the clans and the members of the family or the subjects of the stool own the land forever. So usually it's very hard for them to lose it. You cannot really merely sell it. Nowadays you cannot sell the allodial title. The only way you can lose the allodial title most of the time is where the state will compulsorily acquire the land under Article 20 of the Constitution. So the state has taken the land for the public interest. So it becomes public land. So this means that unfortunately, because you are the true owners of the land, you have to give the land to the state. They want the land for the public interest. You get it? Now, usually in the past, allodial title, you can lose it when they defeat you in battle, but it cannot happen in these days. And then when someone enters the land and discovers your land or something, but it doesn't happen in these days. I hope you got it. But then also the chief cannot give and sell out his allodial title again. because it's now perpetually in the family interest.
Interest.
So allodial title, for allodial title, it's the highest or paramount interest in land. It cannot usually be sold or transferred to someone.
Permanently.
Permanently, except if, even if, especially when it is a stool land or clan land, because it belongs to the people of the stool or clan. In fact, in the Lands Act, if someone wants to even give a large portion of the land to someone as a lease, they must go and do research as to why they are giving out such a large portion. So even you cannot give out large portions of the family land or the stool land to a different group of people for maybe a period of time. So allodial title there is almost untouchable. Then we have the usifact. Usufruct. Usifact. It's a very foreign word, but it's very interesting. It is called beneficiary title. So this one is almost like the allodial title. This one is given to the members of the family or the members of the stool. Now remember, the stool is not a human being. It is like an authority. So if the stool says Oyarifa lands belong to the stool, right, then it is the subject of Oyarifa lands who have the usifact. So they all go on the land, and where they can possess, farm on it and stay there is for them. I hope you are getting it. So they can grant the usifact to another usifact. So that one they can sell or transfer it to another member of the family. So if I'm a member of the family and I settled on this portion and built my house, later on when I'm leaving, let's say Accra, or I'm leaving town, I can sell this whole house and the portion to another member of the family. But I cannot sell it or give it to a non-indigent, someone who is not a member of the family, unless I have the consent or the permission of the allodial title holder. So for families, the allodial title is in the head of the family. But for the stools, the allodial title is in the chief, the stool, which is represented by the chief. So anything that deals with that particular family land or stool land, you need the consent of the family and the consent of the chief. Unless you are transferring the land amongst yourselves, then you don't need the consent of the family. It's very technical. That's why usually, in under Section 31 or 32 of the Lands Act, they said for these technical issues, you need to consult a lawyer. So it's the lawyer or the legal practitioner who draft these particular instruments, because they'll be able to detect which particular type of interest you are transferring from one person to another. I hope you got it. So the usifact is beneficiary interest. You must be connected to the family or to the chief. And the last one is that for the usifact, if maybe you are not a member of the family, but you've stayed there for more than 50 years before you can even get the usifact. So it's very hard for an external person to get the usifact. If you want to get it as an external person, you must be, on the land, according to the Lands Act, Section 5 or so, you must be there for more than 50 years with the consent of the allodial title holder before you can even get the usifact.
With the consent of the allodial
title. So let's look at it as like a hierarchy. The allodial title is at the top. The land belongs to him. The usifact are his two members or family members. So anything that deals with the usifact, the allodial title, they need the consent of the allodial title, unless they are dealing with it among themselves. So if the usifact settles at a particular place, the allodial title cannot come and take the land from him, because he too is a member of the family. He has the right to be on the land. So the third one is the freehold. So the law says under Section 9, you cannot give a freehold to someone who is not a member of the family or the clan or the stool. So freehold is like a perpetual interest. That means that we are giving you the full title, the perpetual title to the land. So that one you cannot.
But you can give it to somebody among the family.
Yes, you can give it to someone. Yes, if it's the customary freehold, you can give it to someone who and if it's stool land or private or family land, that is very hard. That thing is a usifact. So a freehold to a member of the family is the usifact. They've given the land to them forever. So usifact is perpetual. I hope you are getting me. But you cannot give a freehold to a non-member unless he has been on the land for more than 50 years. Then he also gets a usufactory freehold. It's very technical. I hope you got it.
I hear these stories always. Somebody would come and live on your land for a period of time. Maybe you were a squatter on the land. Would live on the land for a number of period. And now they say, no, he stayed on the land for this long. Automatically, it turns his own. Is that the case?
No, that's not the case. It was there's a very old substantial decision. The case of Ohimin and Eji, decided in 1957. The court said that if it deals with land ownership, it doesn't matter how long you've been on the land.
Okay.
The person in that case, the person was on the land for over 15 years
Right.
and was claiming ownership. The court said that no, allodial title, the true owners are those who have been in possession of the land as the true title holders to the land.
Okay.
You get it? Now the issue comes in when maybe you have the right to a land and you allow someone to come and squat there, and the person innocently thought that land was for him.
Okay.
Aha, you get the difference.
Okay.
So that means that the squatter actually thought the land was for him. So he was innocently trying to build.
But it doesn't really mean that when you settle at a particular place for a particular calculated number of years, automatically, since there has been a settlement there, it is yours. It
No,
doesn't
no, no, no,
mean
no,
so.
no. It must be with the knowledge of the original owner. So, for example, if the original owner or the person knew that you are a squatter, and maybe you didn't know, you thought you had a valid right to be there,
Right.
but he knows that you don't have the valid right to be there. So what he does is that he waits for you to build the house or build your structures. Then he comes to sack you. The law will say that from the moment that you knew that the person did not have the right to be there, but allow the person to stay, they'll start counting the years. So usually in the limitation act is 12 years, about 12 years or so. But in law, it can be a law. It's called acquiescence.
Right.
That means that you consented for the person to be on the land, knowing that the person doesn't have the right to be on the land. You cannot just sack the person.
Right.
But people do that for, public lands, land that belongs to the state. They'll be entering onto the land because the government will not sack you. Because politics and many other things, the Achimota lands, it happens. They'll just be entering, you get to enter and then they'll settle there.
Right.
I hope you got
and they will settle there. Nobody would.
Because the state, no one cares. But then the law is even the Lands Act that no matter how long you settle on public land, it doesn't even apply. It's not an excuse. They'll still have the right to sack you. So we don't use "I have stayed on the land for a long period of time" to obtain a right unless you genuinely thought you had a title to the land, you stayed on it, and the other person knew.
Right.
And the person was intentionally waiting for you to build and put your structure there before you come. Because if you win the case, what will you do? You have everything on the land.
Right.
Everything attached to the land is yours.
Right.
I hope you are getting me. So you wait for you to build your house.
Right.
Then you come and say, aha, you are squatting on my land. I'll go to court and I'll win the case. The court say that, so the last, the last 4, 5, 8 years, why weren't you telling the person?
Yeah.
Why did you wait for him to build and all that before, that particular issue came up? I'll be good.
In fact, let me add on to this. I have gotten some cases like that before where they asked me, Bill, the house, when you are selling the house, does it come with the land? Is the land also part? The land is part of the house. You can't take the house from the land. It's all together.
Yes.
So whatever name is on the land, automatically, that is the house.
Yes. So the person usually who is selling the house, right? There's a different agreement for the house and the land. So the house is more or less you are buying the house.
Right.
The land, the person must show you that he has an interest in the land. That you got the land from the original owners, maybe under a lease for a number of years.
Right.
So there'll be a documentation that will show you that, I got this land for 99 years.
Right.
And I was allowed to build on this land.
Right.
So you are buying the house and you are buying the remainder of the years. That means that when the years end, they can go and renew it. Right, to extend the period anymore. So the fact that the land comes with the house, because land means the surface soil and anything that is attached on the surface soil, the buildings and the structures on it, even all the way to the reasonable airspace.
Right.
So the bit of the air above your land is even yours.
Yes.
I hope you got it. Yes,
I get it. Beautiful, beautiful. Touching on it proper. So you say we have the private land ownership. We have the stool lands also ownership. We have the public one.
Yes.
That's the governmental one.
That's the government one, yes.
And you mentioned another one.
So there's two land ownership.
Right.
There is even family. So there's two family and clan.
Okay, that's one.
That's one, more or less like allodial title. Okay. Then there is also private land ownership. That's like in a private individual. Okay. So more or less the private individual is the owner of the land. He has the true ownership of the land, or you got a freehold of the land. So that's the second one. And the third one is land that is owned by the state, right? The government. And then the fourth one, usually, is more or less, the land isn't owned by the state, but there are some instances where, for example, someone commits a crime, you get it, and uses the proceeds of the crime to acquire property.
Right.
The state will seize the property.
Okay.
So it wasn't compulsory acquisition, but it's by court order.
Okay.
You get it. Okay. So there are certain lands that are acquired by court order. So you can win a case against someone, you can even get the land by court order. I hope you got it. So now it doesn't matter the interest the person has in the land. You seized it because the person owed you a debt. And so you come and you seize the interest the person has because he owes you a debt.
Right.
So then you've acquired the land. You know it happens a lot. Someone is a criminal and you use the money from the criminal activities to buy the house. They'll seize it. You get it. So when the state sees it, it's more or less it will come under a different regime, and then probably they can sell it and they can use the proceeds to put it in the national coffers. I hope you got it. So that is it's very rare, but then that's also another portion. It happens a lot. I hope you got
I
it.
see.
Yeah.
But the one who sold the property
Mhm.
has no idea.
So you see, the one who sold the property
Yeah.
didn't have an idea that he was selling it to a criminal.
To a criminal.
So more or less, when the state seizes it, then the person can come and claim something. You get it because of his interest in the land,
Right.
because he has an interest in the land. But that's a whole different matter. Right. So those ones are rare.
Okay.
It's criminal activities. It's under criminal procedure, and those ones are very rare.
Let's move on. Let's
Yeah.
move on. Let's. Okay. So I want to ask this question.
Mhm.
What documents do the court do lands commission require to register your land?
All right. So for this one, because it's very technical, I'll just read out the documents
Just
from.
do that.
Yes. So let me just read out. So the Lands Commission has a website where they've expressly stated the documents. So number one, on the document, you need the stamp.
You
The
need a
stamp.
stamp.
It must be officially stamped.
Yeah.
You get it? And
By a surveyor.
so usually more or less the surveyor would sign on
Right.
it, but you see there'll be an official stamp. It's under the Stamping Act.
Okay.
So all the documents that you are going to register must be stamped so that the state will know that these documents are authentic.
Authentic.
They'll go through a verification process.
Right.
So you don't just write something on paper and go and submit.
Right.
You go through you pay for it to be stamped.
Right.
So for it to be stamped, the officials will stamp it and they'll go through the document to see whether the document is valid or whether there are issues with the document. Then
Right.
they stamp.
Right.
So that's the first thing. Then also that particular documentation can come in any way. It can come, as you said, an indenture, a deed of transfer, a conveyance, a mortgage, a leasehold agreement, etc. There are different forms, but it's not about the agreement itself. It's about the content of the agreement. So they look through the agreement. It must have certain things.
Right.
The date. It must be dated.
Right.
It must have the names of the parties and their signatures, and it must have important relevant terms in there, the covenants, there are certain basic terms in there. So with respect to that, right, once all these things are on the document and the document is deemed to be valid, you also stamp it. Your signature will be on it, etc. I know the third one, which is the site plan, is also an important document you must submit. The site plan is not a drawing. Someone will have to go and prepare a site plan, right, and show the proper demarcation of the land. So the site plan shows three things. It shows the size of the land, it shows the location of the land, and it shows the parties who own that particular portion of land. I hope you got it. So these are the three things on the site plan. And at the back of the site plan, the parties will sign. Then they submit it to the land title registry. Then it also says
now I think now they are even doing barcoded site plans and all that. Lands Commission.
Yes. So
where all the details is on the
back. Yes. So there's this thing known as electronic conveyancing. Right. So now they are using technology to have electronic transfers and all that. So you just have even more or less the signature of the solicitor, the lawyer who prepared that particular document. Right, his stamp or his seal must be on the document. I hope you got it. And then they say also the licensed surveyors and director, the survey and mapping divisions, their signatures must be on the instrument. The signature of the witnesses and all that. Right, and all supporting documents must be attached. So supporting documents can include maybe a judgment, a court judgment that shows that these people were the owners of the land. There's a court judgment that grants them ownership. That particular surveyor's document, the document will have that particular the judgment will have the statement that shows that this land belongs to the owners, so that they also attach the document. So there are a lot of things you submit to the land title registry. They go through the authentication process,
including the indenture.
Yes, the actual agreement, the actual transfer, the land title certificate, any original certificate you had, right? You can also submit it. So it depends on the various interests. And I think let me just take this, right? For example, in the Land Act, if there is no title, there is nothing in relation to the land, right? There is people who are the true owners, they will come to the Land Act with nothing but the site plan. When they submit the site plan, they'll do what is known as a statutory declaration. They'll declare to the land title registry that this land is ours. This is our history. So they'll trace their history,
Right.
and all the original documents or anything that can show their history to the land, they'll trace it. So that means that there was no land title certificate, but they are the original owners. So when they submit it, then the land title registry will record it in the register. So now we have the first recording in relation to the land, the first registration. I hope you are getting it.
Right.
Then these same original owners, if they grant a piece of land to Kofi, the Kofi will come and register. They grant to Ama will come and register. So it will all be under, all those documents to be under one, site plan, under one umbrella with their different site plans. So the different site plan will show the different demarcations. So you come and take this portion, another person come and take this portion, another person come and take this portion, but they are all under the original site plan. So sometimes when you take a site plan, right, from the Lands Commission, you see the demarcations, you realize that there are so many attachments,
Right.
and so many divisions in there. That is all under one family land or stool land. So then the subsequent people, if you want to buy the land, you have to go to the Lands Commission to do a search to show who owns, in relation to the site, who owns the land.
We will get there.
Yeah, I hope you are
We'll
getting
get
it.
there. We'll get there. We'll get there. And also, if you're watching this, kindly subscribe to the YouTube channel. This is Billcotey here. And also, if you want to verify your documents, you already know that we have that function on the app. Okay, so click on or download the app from Google Play Store, App Store, and you can verify your land document. All you need is your site plan. Just go on to the app and you'll be sorted out. Okay.
Walking away. Your words.
Right. So let me just touch on this thing briefly. I want to ask you, how long does the land registration process typically take? How long? Because I know it's a very cumbersome process. Some can take years for it to go through.
Sometimes when you read the law, they'll say once the documents are submitted, it will take 2 weeks.
Yes, but that's not the case.
That's not the case.
There's always a way around it.
Yes. So
Always a way around it.
there are human beings who deal with this kind of things. So usually, more or less, it also depends on number one, how you help the land registry officials,
Right.
The civil servants who are there, because some people don't come with all the complete documentation.
Right.
Some people come with a site plan that isn't approved, and they later on have to do another site plan. So when you even have to do a site plan, it will take some weeks and months to have it delivered to you.
Right.
I hope you got it.
Right.
So I usually tell people that put in 2 months to 3 months at the back of your head. That is for even the most facilitated process. 1 to 3 months, the most facilitated. If I talk about facilitated, people take things to smoothing their hands and all that to facilitate it for you. But then that is another issue altogether, yes. But then under normal circumstances, in the law, it's supposed to take 1 to 3 months. But then in practice, there's a backlog.
It can even take
a year or 2.
Yeah.
So that's the truth. In practice, there's a backlog, and government officials will take things at their own pace. Right. Unless, of course, you're smoothing their hands.
Right.
So those things are
that's illegal.
Well, that's illegal. But then things are, yes. Even passport is supposed to take 2 weeks.
Absolutely.
Passport 2 weeks. But then
how much do you think it will cost you to register a land?
So you see the lands. What happens is that for the land title registry, they always submit the estimated cost.
Okay.
Right, they submit it. So usually, more or less, I do not say it's offered. You just go to their website, right, and then they'll get the land registration cost. Okay, land registration cost for you. So on the website, they could tell you that, but it's not really that expensive, right? Usually, if you have about 2,000 to 3,000 cedis, you are good to go. So they give you the value of the land and then the estimated cost. So it's more or less in proportion to the value of the land. So there are some lands, if it's a small, value, then the estimated cost is there. I hope you got it. If it's a big value, the estimated cost. So for example, if you are looking for a service from the Lands Commission, the Survey and Mapping Division, right, they charge about 72 cedis per copy of some of their documents. The estimated cost of survey is maybe 72 cedis and just say, but
No,
you know that one, you get it.
That's not it, really.
Yeah, so there are so many. So they also have documentation dealing with. So you can actually apply to the land mapping divisions if you want a surveyor. I hope you got it. They'll give you the estimated cost and all that. But then land commission survey and mapping, you can get 650 cedis for a complete survey and mapping. Right? It's on their website. Let me just get more information on the website. So
survey and mapping division, right?
yes, so there's the survey and mapping division, and there's also the even the stamping of the licenses, stamping of the registration,
Right.
stamping of documents. They take money, you pay money for it. But more or less, it is supposed to be made very cheap and affordable for the ordinary individuals, and they usually, update the website with that information.
Okay.
So more or less, I usually tell people that if you ask for the registration cost today, there's a website that has the updated cost, but it's usually not expensive. I want to get the
I mean, sometimes depending on where the land is and all that, the price can actually go up. It can actually go up ridiculously expensive. It can be very, very, very. The price can be very substantial.
Sometimes registration, I see some fees here like 100 cedis, 200 cedis.
Yeah. But then sometimes they can actually go really up.
Yes.
Just a full plot in some areas can even cost you a little about $2,000.
Yes. So more or less, in reference to the documentation and all those things, there are other additional charges and fees. That's why I said people usually don't come with a complete document.
Right.
Just for stamp, because registration is just, they'll stamp the documents and then they'll put it on the register.
Let me ask you, how would you verify your documents? If you want to buy a property, how would you verify your land? How would you verify? What should you do?
Right. So number one, it means that the property wasn't yours at first.
Yes.
Right.
Yes. You are trying to buy the landed property.
Perfect. Now you are buying it from someone.
Right.
Okay. So number one, I usually tell people that on the ground you have to perform what is known as the necessary due diligence.
Okay.
You have to do the background checks.
Right.
The responsibility due to case law, the responsibility is on the buyer.
Right.
The buyer to actually do the background check. Now the background checks in law is called legal due diligence. Right. And as you said, you can even do some verification for people. So people must take the active steps to do the legal due diligence.
Absolutely.
So number one, the identity of the person giving the particular property.
Right.
You must have his full identity, and you must be able to trace his connection.
The Ghana card. Add the Ghana card.
You must be able to trace his connection to the particular property. So someone walks up to you and says, "I'm said Doe. The lands at Oyarifa belongs to the Doe family."
Yes.
You can be able to do your background check
by
number one, going to the land title registry and conducting a search
in all three divisions.
Yes, in all three divisions. You have to conduct a search. So when you conduct a search, you'll be able to get enough information as to probably who owns the particular property. Because obviously the person selling the land will give you a site plan, the location of the land. So you submit the location of the land to the registry or the lands commission, and they'll be able to trace who has who has ownership of that particular land.
Okay, so adding up, just sorry to cut you.
Hold on.
Adding up to it, I would advise everybody, if you want to buy a land, what you are supposed to do also is, apart from the owner serving you with the site plan, you should be able to also get a surveyor who would come on the land to pick the coordinates and go and conduct the search. Don't let somebody give you a site plan and claim that that is his. And what if the land is not that place?
Yes.
It's at
different. Many people can't even read site plans. Obviously, like let's be true. Site plans are technical documents. You see it, you just see some lines and you tell you this pink aspect. No. So you need someone to
surveyor to do that. We have a lot here at Billcotey. We can sort that thing out for you. We can verify your land documents for you. You have no problem.
Right. So once the verification is done, even that is not enough.
Right.
Now in case law, they even tell you that you have to actually go on the land itself and conduct what is known as an eye-opener search. A physical search. You have to open your eyes and see the land that they are trying to sell to you.
Right.
Because obviously, someone will tell you that he's selling this particular land to you. you didn't go to the location, you buy the land, you transfer the money, you come there, and someone has already gated and walled the property.
Right.
Or you go to the property and someone is having a farm on the property. So you are supposed to go there, do the relevant search, and ask the person the relevant questions. Oh, you have a farm on this land.
Right.
Who gave you the right
Right.
to have a farm on this land?
Right.
I hope you got me. Who gave you the right to farm there? You ask the person the question. The person will tell you that, oh, my chief or my family head gave me this land to farm on it. So you'll be able to trace the connection to the chief, because no one just comes to land to farm on it or comes to build a property on it. So you have to go to the land physically and do your necessary due diligence. Ask the neighbors questions, especially if it deals with property,
Right.
right? Especially if there are court cases in relation to it. How do you know that there'll be a court litigation? Sometimes when you go to the land, on the wall, they plastered injunction to tell you that this particular land, even the people do write with red markings.
Yes.
We are not dealing with anyone. It's not for
It's
sale.
not for sale.
Meanwhile, someone is selling you the land,
Right.
but I didn't go there physically. If you went there physically, you see the red inscription that this
Absolutely.
land is not for sale. This
Absolutely.
building is not for sale.
Absolutely. Talking about
yeah.
that, how would you prevent people from encroaching into your registered land?
Right. So the best way to do that is simply contacting the authorities. Under Article 18, you have to enjoy the privacy of your land.
Right.
So the encroacher is actually committing an offense.
Right.
He is trespassing onto your land.
Right.
So you even have the right to arrest him yourself.
Right.
So people talk about the land guards issue. The land guards are actually allowed under law.
Really?
Yes. People
I
have,
never knew.
yeah, or else it wouldn't have been something that is a severe issue. Land guards are allowed under law. You are allowed to guard your land. I hope you are getting me. The same way you guard your saloon, if you have a saloon and it's open, or you have a shop that is open, you have security officers, right? So a security person will be standing guard at your saloon. You see, land cannot be stolen. That's why they put land guards there. The issue is the violence.
Right.
And rather, the person who doesn't own the land is the one who even bring the land guard. You know, that kind of thing. The one who doesn't own the land, because he's rich, you rather bring the land guard to oppress the true owners. That's the issue. But if you are a true owner of the land, you are supposed to guard your land. So what you do is, number one, once you enter possession,
right,
there's a record possession of the land, you build up your structures. You erect a wall on what is known as boundary pillars. You put in boundary pillars, or you start planting economic crops or trees on the land. You have to, plow the land. You have to clear the surroundings, clear the land, and make people know that there is someone on the land. I hope you got
right.
So that people will not be able to encroach.
Right. Okay, so after buying a property, the landed property, how can you prevent double sale of the land? Because sometimes somebody has sold it to you and will sell it to another person. How can you prevent that?
When you buy a property,
right,
there will be a sort of documentation,
right?
As you said, it depends. So the right by the either it's a sale and purchase agreement of the property, or it's even a lease or anything.
Right.
So it's a transfer or a conveyance, right? So to be evidenced by an instrument, a legal instrument. Quickly, the first step is to quickly go to the land title registry and register your instrument. Right? The good thing is that once you register it, it is noticed to the whole world that you have the title to that particular property.
On top of that, they would even do publication.
So
a latter part of the registration.
Yes. So the point then is that anyone who comes to sell that property, right, and another subject or victim buys it, you still have the authority to sack the person, or you won't have any legal trouble. When you go to court, they'll be able to show that you had the legal title first. You registered your title to the land, so you had the legal title first. Unless the other person had an equitable title. Equitable title means that probably the other person bought the land but didn't go and register it.
Right.
And he was on the land and you knew. So you quickly went to register yours first. So you are the second double person. I hope you are getting.
You have not registered. The first person didn't register it.
So, but the law says that he has equitable title. If you knew, if you knew that he was on the land or someone was on the land, you are not a bona fide purchaser. A purchaser in good faith.
What if you didn't know?
So that one is a different issue. So if you genuinely didn't know, you did your background checks and you did everything right, and you genuinely didn't know that someone was on the land or someone had the right to the land, then your legal title will override that person. So there are two types of title, the legal title and the equitable title. Once you register your interest, you have the legal title. So the person doesn't register, but has a good claim to the land,
Right.
has an equitable title.
Right.
So the thing is that registration takes a period of time. As you say, it can take 1 year or 2 years. So why is it that if I'm registering or I'm in the process, because I've not yet registered, I don't have a legal title,
Right.
but I have an equitable title. Sometimes they can give you a provisional certificate. I hope you get me. So in that sense, when the second buyer is coming and he quickly goes to buy and register, he facilitates the registration. That means that he's the second buyer. He knew someone was on the land and
he
quickly,
decided to.
yeah. So that one, he wouldn't override the equitable title.
Okay.
But if the second buyer is innocent, he's an innocent buyer, and he did all the relevant checks and due diligence, and he goes there and realizes that, oh, there was no one on the land, and then he registers the interest in it, then in that particular case, he gets the legal title. So the onus, the responsibility is on the person who is buying to quickly do the relevant checks. That's why when you register, it will be constructive notice to the whole world. So anyone who wants to buy land must go and do the search first at the lands registry. I hope you are getting me. Do the search, because once you do the search, the legal title will show up.
Right.
And if the legal title shows up and you continue to buy, you've lost your money. Yeah, so there are so many cases like that. And that's how they are able to prevent that. Register your interest. And that one, the law says that you notified everyone.
Okay. Okay, absolutely.
Walking away. Your words.
So what also if the land is not registered, unregistered land, undocumented lands, how would you also deal with those things? How would you go about it?
If the land is not registered or documented, and probably
But it's been sold to you.
it's been sold to you, so more or less maybe
You knew that it's not registered.
yeah, then the responsibility is on you. That portion that has been sold to you,
Right.
you quickly do the site plan,
Right.
and you go and register your interest, because as I said, any particular sale or transaction is registrable. So even if it's a lease or a freehold or a customary freehold, common law freehold, customary freehold, it's a usufruct, any transfer or conveyance is registrable. Section 80, 81, 82 of the Lands Act, they will list it for you. Even a mortgage is registrable. So you have the responsibility to go and register your interest.
Right.
I hope you got it.
Absolutely.
So even though the land is not the property hasn't been registered, you can go and register your interest in that particular property. Yes.
Okay. Fraudulent activities. How can you prevent that? That's something that I think is very prevalent.
Yes. So I believe that most Ghanaians fall for these fraudulent activities because they do not do the necessary legal due diligence. In fact, it was so bad that the Lands Act, those who were making the law decided that, look, in section 31, 30 to 35 deals with the transfer, the conveyance, right? If you want to transfer your interest in the land to someone else, so you want to buy, you want to sell, whatever, right? Let a lawyer do the due diligence. Let a lawyer create the transaction for you.
Right.
So it's actually stated in law that a legal practitioner must be the one to draft the document. I hope you got it. The transfer or the deed. He's the one to draft it. You know why? Because the lawyer knows the extent and the consequences attached. So what the lawyer will do is that the lawyer will advise you to start a process of legal due diligence. That means that they are experts in that.
Right.
So as you said, you're an expert in this field, the real estate and construction. So you have your team of surveyors.
Right.
You have your legal team.
Absolutely.
So people will do the work. So if you decide to go and buy land on your own, and someone is just giving the land and decide to do everything on your own, you're the one putting yourself in legal trouble.
Right.
But if you consult a lawyer or a practitioner in the field, and the person does the due diligence for you, you save yourself a lot.
Right.
Anyone who buys land in Ghana without going through the process of a verified real estate company like yours or a verified legal practitioner, right? The person is likely to face issues.
Right.
Because already there are lands that are being sold right now today that is not even the owner who is selling it. I hope you got it. So how do you know? It's someone who is an expert in the field that will do the necessary verification and due diligence. All that you've said today, people didn't know it. So that means that we are experts in the field. I hope you got it. So the expert, right, even the law, it says let the expert draft the documents for you.
Yeah.
Right. So you go to that section 31, you see it there. Legal practitioner to draft it, or someone who is, an expert or practitioner in that field, right? Who knows what is supposed to be done. The person can also help you with it. But then more or less, it must be an expert in the field, right? Who has the authority to do the verification and the checks for you.
Absolutely.
When that is done, yeah, you are good to go.
Absolutely.
Yes. So
absolutely. Thank you. Thank you very much. And sometimes also they say you go to a land and there are blocks, you have to pile sand on the land just to show that this land belongs to you
Yes.
and all that. All these things, somebody will not even show up. But at the end of the day, after putting up the structure, you would come and claim ownership of the land.
Yes.
So some of the
If you don't have the right to the land
Mm.
and someone sold you a fake interest,
Right.
no matter what you do, you have a fake interest.
Absolutely.
I hope you got it. So someone doesn't own the land, he sells it to you. No matter what you do, you have a fake interest.
Right.
So it's not you constructing your house people will even be constructing day and night. They'll be building the night
Quickly.
like because they know that something is wrong.
Something is
you know
wrong.
and that one doesn't save you.
Yeah.
Because once you have a fake interest, that's it.
Right.
The only thing that will come to your aid is where you have a fake interest. The true owner knows you have a fake interest, but then he decides to let you continue. So you come and take an advantage of that. The court will say, no, don't try to also take advantage of people. Don't let people build and come and seize their properties. So you best take legal action or stop them first. Right. So nowadays, when you enter land, immediately, the opposition, those who are already the owners, they'll come and stamp a letter. They'll send you legal letter telling you that you don't have the right to the land, etc. And you have to ask questions. Trust me. There are people on each land that are the watchdogs. If you go to every community, there are people who have eyes. They know. So when you tell them that who owns this land, they'll be able to trace and tell you. Yes. So you need to talk to these people too. That is a legal due diligence.
Right.
Yes.
I mean, that's why we are here, as you, Lawyer Doe, already said that we can sort that problem out for you. And I would also advise clients, buying a land sometimes is a haggle. You have to take your time. Buy it from developers, because for them they've been through the system countless number of times and they are okay. They are conversant with the process. Okay, just buy a property, already built house property rather than going to buy a land. That's what I advise. Actually, that's what I advise. Thank you, lawyer. Thank you very much.
You're welcome.
It has been a very fruitful conversation. Kindly subscribe to the YouTube channel. This is Billcotey. There will be a next episode coming up also after this. And if you've not watched the previous one concerning marriage, splitting your properties whilst you guys are divorced and all that, check it up there. You'll see the link up there and watch that. Thank you very much. We are out of here.